to welcome you to Washington Legal Foundation. I'm Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 39th year of continuous public interest law, policy, and advocacy on behalf of free enterprise and free market principles. In addition to putting on programs such as this one, we litigate. That was our founding effort and something that we've been doing, I think, to great effect for the last 39 years. Filed amicus briefs and original actions in all levels of federal and state courts. The Legal Studies Division that I am Chief Counsel of is our publishing side. We put out a wide range of papers on a good number of issues. Some of those were available for those of you who are here personally downstairs, and those of you who are online, you can check those out when the program is over. They're all on our website. And also, we put on web seminars. We have a blog, the WLF Legal Pulse, that gets involved in a lot of these same issues as well. What our speakers today are going to address is whether the Federal Communications Commission has been abiding by the limitations Congress placed on it in the Telecommunications Act and the strictures imposed by the U.S. Constitution. Cases involving the Commission's open internet rule and its order that states not preempt certain decisions by municipalities regarding publicly owned broadband services are two instances where statutory and constitutional strictures were at issue. The tension between those limitations and FCC's regulatory aims has also arisen in not yet finalized rules. For instance, the nearly ready ISP privacy rule ignores, as WLF argued in its comments, Telecom Act Section 706's instruction that the FCC, quote, deregulate the industry to encourage and accelerate the deployment of telecommunications. Judges presiding over suits against the FCC have acknowledged that the agency deserves some amount of deference, but as Third Circuit Judge Ambrose noted in the May 25, 2016 Prometheus Radio Project versus FCC decision, quote, at some point, we must lean forward from the bench to let an agency know in no uncertain terms, enough is enough. We'll be talking about some of those cases as well as others today. If you are online and you have questions for us, please email us at interactive@wlf.org. We'll be live tweeting the program as well. The hashtag is WLF Events. I'm going to introduce the speakers in the order in which they will make their presentations, and then we will take questions. Commissioner Ajit Pai was nominated to the FCC by President Barack Obama and was confirmed unanimously by the U.S. Senate on May 7, 2012. Prior to his nomination, Commissioner Pai was a partner at Jenner & Block, worked as Chief Counsel and Deputy Counsel on Senate Judiciary subcommittees, and also held numerous positions in the FCC's General Counsel's office. The second speaker today will be Harold Furchtgott-Roth, Director of the Center for the Economics of the Internet at the Hudson Institute. He also founded Furchtgott-Roth Economic Enterprises in 2003. He was confirmed as an FCC commissioner in 1997 and served in that role until 2001. He is the only economist to have ever served at the FCC in that capacity, a mistake that Harold says they will never make again. He said it, not me. Speaking third will be Brett Shumate, who's a partner with Wiley Rein in its Washington, D.C. office. He previously was a law clerk to Judge Edith Jones on the U.S. Court of Appeals for the Fifth Circuit, and he's also representing one of the petitioners in U.S. Telecom versus FCC before the D.C. Circuit seeking invalidation of FCC's open internet rules. Commissioner Pai, if you could get us started.
Sure. Well, first, Glenn, thank you for the introduction. Thanks as well to the Washington Legal Foundation for hosting this event, in particular its General Counsel, an old friend of mine, Mark Chenoweth. I also want to say it is a particular privilege to serve on the panel alongside my friends, Harold Furchtgott-Roth and Brett Shumate. It is somewhat intimidating, I have to say, though, being paired with a brilliant economist and a star of the Washington Appellate Bar. So in the interest not so much of time, but of humility, I will keep my remarks relatively brief. One of the great things about the Federal Communications Commission is that its jurisdiction is broad. It covers virtually anything having to do with the communications sector, but that authority is limited. We are, after all, an agency that is created by Congress, and Congress set forth in very particular terms the limits of our authority, both within the Communications Act of 1934, as it's been amended over the years, and also generally through the Administrative Procedure Act. Those are restrictions that I take very seriously. And the reason why, if you read some of the statements I've made, often in dissent, is that we are often presented with, or we come up on our own with, ideas that might be good policy. They might not be, but they might be.
But the question isn't necessarily, is this good policy? And we leave it at that. We also have to make sure that our proposals comport with the Communications Act, with the APA, and of course with the Constitution. And I think in recent years, one of the ways in which the FCC has gotten into trouble is by forging ahead with what it considers to be good policy, regardless of the legal consequences. And we have often seen, of late at least, various courts across the country that have overseen the FCC and vacated or reversed some of its decisions. The most prominent of which I'd like to discuss briefly is the one that Glenn referred to with respect to the municipal broadband decision. The FCC in 2015, in a party line vote, decided to preempt the laws of Tennessee and North Carolina. The state laws in question allowed the municipalities in those particular areas to offer broadband service within the city limits, but it said you can't go any further. You can't provide broadband service beyond the city limits. And the FCC decided to preempt those state law restrictions. And the argument I made in dissent was pretty simple. From a policy perspective, I don't have any particular insight into whether or not a Tennessee municipality or North Carolina municipality seeking to provide broadband service is a good idea. I leave that to the people and the elected officials in particular of those states. But what I do think is that there's a legal question here, which is that under our constitutional system, does a federal agency have the power essentially to rewrite state law to fit its own preferences? And as I read the law in question, I did not think that it did. The Supreme Court has long said that if a federal agency is going to preempt state law restrictions like the ones in question, then Congress has to speak very clearly. This is known as the clear statement rule. And I said, look, the clear statement rule clearly applies here. And as far as I can see, there's nothing in the Communications Act that suggests that Congress was speaking clearly on this question. The agency, for example, was putting all of its eggs into the basket of what's known as Section 706 of the Telecommunications Act. And that section says nothing whatsoever about preemption. It does say that the FCC has to promote competition and reduce regulatory barriers, but that doesn't seem very clear to me, especially when you consider a 2004 case called Nixon versus Missouri Municipal League. And in that case, Justice Souter, writing for the court, held that Section 253 of the Act was not a clear enough statement, according to Gregory v. Ashcroft, the clear statement case, to suffice for purposes of preemption. And that was telling to me because Section 253 Act, number one, explicitly mentions preemption, and number two, it's exceedingly broad. It referred to this commission preempting any entity from engaging in conduct that might have the effect of limiting the provision of telecommunications service. So my argument was, look, if the Supreme Court has said that Section 253 doesn't suffice for the clear statement rule, there's no way that Section 706 does. Fortunately, the Sixth Circuit Court of Appeals, which handled the challenge in this case, saw it my way. And in a recent decision, they held, yes, the clear statement rule applies. The Section 706 is anything but clear on this point. And they've reversed the FCC's decision. And I didn't take any particular joy in that decision. What I have said, though, is that we should make that analysis for ourselves up front in a very serious way, as opposed to the traditional thinking in some quarters, which is that throw as much as you can on the wall and just see what sticks when it comes to court. That, it seems to me, is putting the cart before the horse. The first question, not the last one, should be, do we have the power to do this? There are a number of other areas in which the courts have challenged and reversed what the FCC has decided to do. Another case I'll mention briefly involved a Third Circuit case known as Prometheus. Prometheus 3, actually, since this is the third go-round we've had. This case involved the FCC's media ownership rules. And one of those rules is known as the local television rule. And it says that no company can own two or more entities within a single market if one of those entities is in the top four of the marketplace, and so long as there would be 8 independently owned and operated stations that would remain post-merger. Now, the FCC in 2014 decided to tighten that rule substantially through what's known as the attribution of joint sales agreements. And a joint sales agreement, or a JSA, is basically a contract between two television stations in which Station A says, I will sell the advertising time for 15% of your advertising time to Station B. And Station B says, okay, well, we'll go ahead and do that. The FCC decided to wrap that restriction into the local television ownership rule. And the argument I made in dissent was that, look, the FCC can't adopt these JSA restrictions without first determining whether or not the actual local television ownership rule is in the public interest, which it had not done for many, many years, contrary to Section 202H of the Telecommunications Act, which compels us to make a decision every 4 years. I said, look, I've found all of this evidence in the record to suggest that joint sales agreements are pro-competitive. They provide benefits to viewers in those communities. I think the FCC should consider it within the context of its overall review of media ownership regulations. And in particular, we can't do it until we revise that local television ownership rule. Unfortunately, the FCC majority decided to reject that proposal, and they said, well, you might have an argument, but we'll consider it in a couple of years when we look at the local television ownership rule itself. And luckily, the Third Circuit stepped in and said, no, that's not good enough. I mean, by definition, you can't tighten a rule if you haven't yet determined whether or not the rule remains in the public interest. That seemed to be a fairly common sense application of the law, to me at least, and I'm glad that the Third Circuit saw it our way. There are a number of other decisions that I'm sure my distinguished panelists could bring up, and I'm sure they will. But I think all of this goes to a basic question. What is the purpose of a federal agency? Is it to reach out for good policies and pursue them no matter what the legal constraints? Or is it to figure out what can we do within our authority to promote the public interest? My vision, since I've had the privilege of serving at the FCC since 2012, has been the latter, that within our power, I'm more than willing to do whatever it takes to promote competition, sound regulation, and policies that respect the principles of economics. But again, as an agency with limited power, as set forth by Congress, we simply can't do what we think and say the law be damned. So hopefully we have an interesting discussion along those lines. Look forward to the questions from the audience, either here in real life or virtually. And thanks again to the Washington Legal Foundation for inviting me.
Thank you, Commissioner Pai. Harold?
Thank you. Thank you, Glenn. Thank you, Washington Legal Foundation. It's a great honor for me to be here on this distinguished panel. It's a great honor to be on the same panel with Brett and Commissioner Pai. For the record, I want people to know that Commissioner Pai just gave these paragraph perfect statements without a single note. Right? This is all pretty much from memory. I am not nearly as clever as Commissioner Pai, and so I'm going to have to depend on my handwritten notes here, which imperfect though they be. I've been asked to particularly focus on the history of FCC overreach, and it's a long history. It goes back to the very beginning. The first Supreme Court case involving the Commission arguably was about Commission overreach in a case called Pottsville. I think you can look at the three types of major court cases involving the Commission. I would put them in three broad categories. The first is in the context of statutory interpretation within the Communications Act broadly. Is reasonable people can disagree about the definition of license renewal in the case of Pottsville. I don't think it was a case of really Commission broad overreach, as we'll see in the next two categories, but there was still some question about whether the Commission could really do what it was trying to do. The second category is where the Commission is trying to do something that is clearly not in the statute, but it's trying to find some permissive language in the Communications Act that will permit it to do something a little bit more broadly. In this category, I would put the NBC versus U.S. case in 1943, where the Commission was trying to do chain radio broadcast regulation, even though there really wasn't anything specific about that in the Communications Act. I would also put Red Lion, 1969, where the Commission was regulating speech on the basis of some broad interpretation of the statute. But this second category, I would say, is still within what I would call, well, this is generally, you could hypothetically imagine that it's something Congress might have written, but they never did. it's a more aggressive interpretation of commission authority. The third category is what I would call disputes across jurisdiction, which is to say the commission is not only going to be applying regulations that enhance its power, it's going to be applying regulations and interpreting its authority in ways that diminish or circumvent the authority of entirely other agencies or entirely other states, as in the case of Tennessee, North Carolina, the FCC. I would also put Iowa Utilities Board from the 1990s, City of Portland, the most recent U.S. telecom case, which would circumvent Federal Trade Commission activity. So I have these kind of three broad categories of FCC overreach. So it didn't begin this year, it didn't begin last year, it didn't begin 10 years ago. It really began back in the 1930s, where you have this entity, an independent agency called the Federal Communications Commission, which uses its combined authority not only to write rules, but to enforce those rules and to adjudicate those rules, and to adjudicate disputes under those rules. And one of the outcomes of combining all of the powers of government in one entity, which has been written about by great political philosophers over the centuries, is that you wind up with lots of problems. And one of those problems is, I think, very visible in its effort to try to reach beyond its organic statute. I was going to talk a little bit of detail about the Tennessee and North Carolina case, but I'm very glad that Commissioner Pai has done that. For those of you who may not know, Washington Legal Foundation filed a wonderful amicus brief in that case, which they very charitably allowed me to sign my name to as well. And the arguments that are in that brief very much reflect the arguments that Commissioner Pai made in his dissenting statement, and that were ultimately adopted by Judge Rogers of the Sixth Circuit, I think actually without a lot of direct attribution either to Commissioner Pai or to Washington Legal Foundation, which is actually the very best way it should be. No fingerprints. But it was this clear statement doctrine. What is very striking to me is if you look at parallel decisions, U.S. Telecom involving what's commonly known as network neutrality, which is completely larded with Chevron deference, efforts of the court to try to find ambiguity in language where there is no ambiguity, efforts of the court to try to sort of say, well, you can, it's really complicated, and the agency can do what it wants to do. The D.C. Circuit never had anything remotely similar to a clear statement doctrine. Now, admittedly, that may be more of a federal issue, but the first prong of the test on Chevron deference really is there any ambiguity in the language? And of course, there really wasn't any ambiguity in the language. You really have to do a lot of somersaults to find the idea that broadband internet access service providers, as the Commission defines them, could possibly be under Title II. It's just not there. The statute's very clear as to what services are limited to be common carrier services, and broadband internet access service providers are simply not there. Let me make two footnotes on that. One is, again, Washington Legal Foundation wrote a brilliant amicus brief in the U.S. Telecom case, which again they charitably allowed me to sign my name to, on First Amendment issues, which I would say go to constitutional issues, which frankly I think the D.C. Circuit did not address in any detail. They just kind of waved their hands, and I understand courts don't like to address constitutional issues when they don't have to, I hope at some point in time some court will decide to do that. Another footnote, though, is I'm not sure that anyone's actually covered by it, because I think the Commission's definition of a broadband internet access service provider is constructed in such a way that there is no entity in the world that possibly qualifies. Because the definition that is now part of the CFR says a broadband internet access service provider is an entity that can communicate, roughly communicate two ways with all or the vast majority of internet access points in the world. The vast majority of internet access points in the world are foreclosed from access by U.S. Entities directly because they're in countries that block. And certainly commercial entities in the United States don't have direct access to them. So I think there's an argument to be made that there's a nullity in the definition. I toss that out for all the lawyers in the room to go scurry back. I don't think the Commission would agree with that. I don't think the D.C. Circuit would agree with that, but I toss it out as something that has been troubling me for the past few months. But I think if you look at those two cases and try to, why is it that the Sixth Circuit very quickly was able to not even reach Chevron, and why is it that the D.C. Circuit, in this case and in a series of cases involving the Commission, always immediately goes to Chevron and really, I think, very often avoiding the first prong of the Chevron deference test. So I toss that out. Let me just quickly, in two more sections, one on the historical role of commissioners. When I arrived at the Commission back in 1997, commissioners, I think it was actually a much more welcoming environment at the Commission than it is today. I met with every bureau chief, every head of every office. I was allowed access to any information, and the chairman made it very clear. Tell them everything. Just don't withhold any information. There was one exception. It was the Office of General Counsel, and the Office of General Counsel is a very nice. First John Nakahata and then Chris Rein, very, very wonderful people. They said, well, the tradition of the Commission is that the chairman controls all of the litigation strategy, and the commissioners have absolutely nothing to do with litigation strategy of the Commission. Being a dumb economist, I don't know. And that was kind of how it worked while I was there. That's what I was told, and other people have told me, yeah, that's kind of how the Commission operates. There was one exception, which was the next wave case. I became very suspicious about the Commission's policy on next wave because we had one policy which was supporting bankruptcy court control of licenses, and then at some point we flipped. We did a 180 and sort of said, oh no, the world will fall apart if bankruptcy court has control of licenses. And it all turned out to be about next wave. And I quizzed the General Counsel, and it was not a pretty situation. But I would put the next wave case in the third category about disputes over areas of jurisdiction, as to say, who controls the licenses of entities that are in bankruptcy? Is it the FCC or is it a bankruptcy court? And again, this was an effort by the Commission to diminish the authority of another legal entity. I would contrast the situation of the Commission on the complete lack of influence of commissioners on litigation strategy with the Federal Trade Commission, which is pretty much a common law case-specific approach. And my understanding, although I've never been at the FTC, is that the commissioners at the FTC actually have a lot of input into at least some of the legal strategy, and all of the cases actually have to be brought up for a vote, which is not the case at the FCC. Just in closing, I just want to note that there are questions about will Congress and the American public put up with kind of the excesses of an independent agency such as the FCC. There's a lot that Congress could do, primarily through the budgetary process, which has been unexercised for much of the past 25 years. So there's a lot that Congress could do to get greater control over the activities of the commission, which I think actually would ultimately be a useful thing to do. Because keep in mind, under the Constitution, Article 1, it's Congress that is responsible for all lawmaking, and I would say rules at the commission are laws of the land, and ultimately Congress should have some responsibility for that, and they've largely abdicated that responsibility for a very long time.
Thank you, Glenn, and thank you to the Washington Legal Foundation for inviting me to participate in this very timely event. I also want to thank my honorable co-panelists for sharing their perspectives. I'm pleased to share my perspective today as one who's been down in the trenches litigating against the FCC for many years, most recently in the net neutrality appeal, and I hope to bring a practical perspective to our discussion and provide a little context to what I've been seeing. I just want to be clear, I'm speaking today on my own behalf and not on behalf of any firm clients. I'd like to share with you two problematic trends that I have seen at the Commission, and like I said, try to put these into a little bit of a larger context. The first trend I see is that the Commission has been aggressively seeking to expand its jurisdiction into new areas. As you probably know, this is not a phenomenon that's just limited to the FCC. It seems that every agency from EPA to HHS has been trying to regulate in new areas and new aspects of the economy. But I think the FCC has really taken expanding its jurisdiction to a new level. I want to give just a few examples and then try to provide a theory as to why I think the Commission has been so aggressive in testing the limits of its both statutory and constitutional authority. First example is in the original Open Internet Order in 2010, the Commission interpreted a policy statement in the 1996 Act, Section 706, as providing authority to regulate the Internet, even though the Commission had interpreted Section 706 for at least a dozen years as not conferring any authority at all. The second example is in the 2015 Open Internet Order. The Commission subjected ISPs to the most onerous common carriage regulation in Title II of the Communications Act, even though the Internet had flourished for decades under a successful bipartisan light touch approach. Third, the FCC is now proposing to reshape and extend a statute designed for telephone privacy into a comprehensive internet privacy and cybersecurity regime, even though there's another agency, the FTC, that has a good track record on these very issues. I think there are probably many reasons why agencies are seeking to expand the limits of their authority, but I think the Commission is unique among federal agencies because I think it's fighting a battle for relevance in the 21st century. You see, in today's internet economy, unless the FCC expands its regulatory mission, it risks fading away like the old Interstate Commerce Commission. Let me explain. In the 20th century, the FCC's job was pretty well defined. It was regulating telephone service, it was regulating radio, it was regulating cable. But now everything has changed because all forms of communications are converging on the internet. You don't have to buy a newspaper anymore. You don't have to buy cable television. You don't have to go to the movies anymore. The internet makes all of this possible, and there's no question that these developments are a good thing for society. But for the FCC, these changes are an existential threat. The internet is replacing the traditional modes of communications that the Commission has historically regulated. If everything is moving onto the internet, but the FCC has no authority over the internet, then what role is there for the FCC to play in today's regulatory space? That's why I think we're seeing the FCC so aggressively seek to expand its role when it comes to the internet. That's where the action is going to be in the future, and the FCC wants to be the cop on the beat so it can stay relevant in the 21st century. Unfortunately, I don't think Congress or the courts have effectively restrained the FCC when it expands its legal authority. Although the DC Circuit twice struck down the FCC's net neutrality rules, the Commission had the political will to persist, and so we ended up with net neutrality grounded in Title II of the Communications Act. As you all know, the DC Circuit upheld that decision this past summer. My co-panelist mentioned that. That case is still pending on rehearing, and my hope is that the end of this story has not yet been written. but I'm afraid that the DC Circuit's decision will have an emboldening effect on the commission. Indeed, the Supreme Court's decision in the City of Arlington requires courts to defer to agencies when they seek to interpret the scope of their jurisdiction. To put things in perspective, the commission has an 81% success rate in the courts of appeals, and the DC Circuit defers to the commission in 89% of cases. Those figures are from an upcoming Michigan Law Review article. When you're getting Chevron deference 89% of the time, I think that's not much of a limiting factor in how the commission goes about making its decisions. And because the DC Circuit so extensively deferred to the commission in the net neutrality case, I think you're likely to see the commission try to continue expanding its authority over the internet into such areas as internet privacy, cybersecurity, data plans, and whatever else the commission might view as kind of the next domain for regulatory relevance in the 21st century. The second trend I see is that process seems to have been thrown out the window at the commission. If you're an agency and you need to expand your jurisdiction to stay relevant, I don't think you let a little thing like process stand in the way. And what I mean by process is not just the APA's notice and comment rulemaking procedures. I also mean a commitment to transparency and fairness that give the agency's policies a stamp of legitimacy. Remember, we're talking today about an independent agency that is politically accountable to no one. So I think it's imperative for this agency in particular to follow procedures that allow the public to know exactly what it's up to and to provide meaningful opportunities to participate and comment on what the commission is proposing to do. But these days, I don't think the FCC is too concerned about transparency, fairness, and the APA's requirements. I just want to share one example, and that's the commission's continuing use of fact sheets as a substitute for notice and comment rulemaking. Don't be fooled by the chairman's fact sheets. They are not your friend. They are a trap. Let me explain. So here's how the APA says a rulemaking should work. The FCC starts by issuing a notice of proposed rulemaking that seeks comment on the actual rules the commission intends to adopt. The commission reviews comments and then adopts final rules. So long as the final rules are a logical outgrowth of what the commission proposed, there's no APA process problem because everybody had a chance to comment on them. By contrast, here's what the commission is now doing in rulemakings. The FCC starts by issuing a notice of proposed rulemaking that looks a lot more like a notice of inquiry. For those of you who don't know, an NOI simply asks for proposals from the public, but doesn't actually propose any rules that the commission intends to adopt. More often than not, what the commission will do in an NPRM is just ask broad questions that are more representative of an NOI. How should we regulate the internet? How should we protect internet privacy? Commenters do their best to answer those questions, but they can't possibly offer informed comments because the agency hasn't actually proposed what it intends to do or where it intends to go. After reviewing the comments, the chairman will then issue a 3-page fact sheet saying he has proposed new rules to his fellow commissioners. Let's be clear, the fact sheet is really just a PR statement for the media. It's not a substitute for an NPRM. It doesn't give regulated businesses enough detail to know what the commission is actually proposing to do. And even if it did, it doesn't provide enough time to actually comment on it. So the next step in the process is that the other commissioners will then vote on the chairman's new rules, but nobody outside the commission gets to see their new rules until after the commission votes on the order and then releases the order. Now, let me explain why I think that the fact sheets are a trap and not your friend. You might think the fact sheets are an example of open government, the commission going above and beyond what the APA requires. Wrong. The FCC is going to take your reaction to the fact sheet and then try to use it against you. So the natural reaction to a fact sheet is proposing new rules is to complain about it. Write a letter to the commission saying this violates notice and comment requirements and what the commission is proposing to do violates the APA, is unlawful or whatever. Indeed, litigants are required to exhaust their arguments at the commission before they go to court. So there's a risk that if you don't complain to the commission about the new rules in the fact sheet, you might be barred from challenging the final rules in court. But if you do complain about the fact sheet, the commission has you there too. Here's how. If you go to court arguing that the FCC violated the APA by failing to notice the final rules, or the fact sheet rules in the NPRM, the FCC will say that any error was harmless because your complaints about the fact sheet show that you had actual notice of the final rules. Now, the DC Circuit actually bought this argument in the net neutrality appeal. You might remember that the NPRM in that case proposed to adopt net neutrality rules under Section 706 with Title II identified as a potential alternative source of authority. The FCC later issued a fact sheet weeks before the commissioners voted, making clear that the commission was now focused on Title II. And then there were multiple filings complaining about reclassification of mobile broadband under Title II. The FCC then argued, and the court agreed, that any APA violation was harmless because the petitioners had actual notice of the final rules and what the commission was planning to do, since they had complained about it on the record after the commission released the fact sheet. Now, earlier this month, the commission issued another fact sheet in its controversial internet privacy proceeding. The fact sheet is a 4-page summary of new rules. It doesn't indicate how the commission is resolving more than 500 questions it asked in the NPRM, and it doesn't contain the text of the final rules. I have no doubt that we will be seeing many surprises in that order when it's finally released in the commissioner's vote. But really, I think the entire rulemaking is a waste of time if the commission hides the ball at the outset of the proceeding by not issuing a proper NPRM, and then uses a fact sheet as a substitute for an NPRM at the end of the proceeding. So where do we go from here? I certainly don't have all the answers, but let me offer 3 prescriptions. The first is that I think the people's elected representatives need to have a say in the important questions that the commission is now deciding by itself. The commission should not be expanding its mission without input from Congress. Whether the commission should be regulating the internet, and if so, to what extent, is really too important of a question to be answered by an independent agency that's not politically accountable to anyone. Second, the commission needs to reform the way it conducts its business. It's often said that sunlight is the best disinfectant, and I want to commend our Commissioners Pai and O'Reilly should be commended for their efforts to press the commission to be more transparent in how it conducts its business. Third, the courts need to be more aggressive, I think, in holding the commission's feet to the fire when it exceeds its delegated authority and violates the APA. If the courts excuse the commission every time it oversteps its bounds, then there's really no incentive for the agency to follow the rules that Congress designed to ensure open government and transparent policymaking. I think it's noteworthy, as my co-panelists have mentioned, that the FCC's most significant losses this past year in court have been outside the DC Circuit, in the 6th Circuit, and the 3rd Circuit. I think those judges might be less inclined to defer to the commission, and I think you're going to see more cases being brought outside of the DC Circuit, given the trend at the DC Circuit. Thank you.
Thank you. I want to give Commissioner Pai and Harold an opportunity to comment on anything that has been said so far.
One thing I will say is, with respect to Brett's excellent presentation, I especially appreciate his focus on process. As he mentioned, Commissioner O'Reilly and I have been focused on that for some time. I think to the average American, it would seem rather strange to say that an agency will only let you see what it's going to do after it's voted on doing it. After all, Congress, when it considers legislation, puts it up on a website well before a vote, at least in ideal circumstances, lets people have public input. The procedural shenanigans we see in the FCC of late that Brett described are really inhibiting, I think, openness and transparency and good government generally. The other point is that it also yields bad outcomes. We've seen in recent proceedings, for example, which haven't necessarily proceeded to litigation, but for example, with respect to set-top box reforms, the bad process that was used to essentially shield the Commission's proposals from public scrutiny have ultimately led to dissent within the Commission, among the Commission majority, and widespread opposition from among the potential regulatees who don't have any insight into what the agency is actually doing. And I would like to think that we could avoid some of those train wrecks on the back end if we could just be much more forthcoming on the front side of things.
I would just say that each agency has its own set of internal administrative rules that are layered, I guess, beneath the APA. I will just note that in discussions with individuals at other agencies, they're always amazed at how quickly rules get through the FCC. In some other departments, it can take 4 years on a fast track to get a rule through. The FCC, when it sets its mind to do something, can get it through very quickly. And a lot of times it's because the Commission can take shortcuts that other agencies would never dream of.
One thing I wanted to ask Commissioner Pai is about the actions that FCC has been taking with regards to so-called blocking of wireless actions that you had dissented, as well as Commissioner Riley, that the agency is doing what FTC frequently does, which is sort of setting policy by taking enforcement actions. Could you talk about that a little bit?
Sure. The cases that you're referring to involved some hotels that were blocking, allegedly, individuals' access to Wi-Fi. And the argument there was that, look, the FCC needs to take enforcement action here to make sure that those signals aren't blocked. And I said in dissent, as did Commissioner O'Reilly, I enunciated a basic principle. Before an agency of any kind can enforce a rule, the rule has to exist. I don't think that's too provocative a statement when it comes to due process. The problem here is that I had long advocated for the FCC to think about what rules should govern this space. And the agency, and one of the petitioners in that case, had explicitly asked the FCC, look, we need to know what the rules of the road are. We'll abide by them, but we need to know what they are. And the agency dismissed that petition, ironically enough, and said, we're not going to give you any guidance. You're sort of on your own to figure out how to navigate whatever the potential regulatory thicket is. Ultimately, when the agency did take enforcement action, it came in the form of very flashy press releases. They were protecting consumers, were promoting Wi-Fi, et cetera. But the basic question of what was the rule in question was never really addressed by the Commission's majority. And so here, too, I think it's a question, not obviously of how a court has ruled about the FCC's decision, but what are the rules to begin with? And I think that's an elementary question in a number of cases, in particular this one, the Commission simply hasn't given an answer to.
Mm-hmm. How long has it been the practice at the Commission that the chairman basically controls the litigation agenda vis-a-vis what FTC does? Is that something that's been traditional from the start, or how has that sort of evolved over time? Has it always been that way?
No, sorry.
No, go ahead.
No, you've had longer experience than I do in this area.
Not that much longer. My sense is it certainly has been going on for, say, the past 30 years or so. I haven't really spoken with anyone who has an institutional memory, or past 40 years. I haven't spoken with anyone whose institutional memory goes forward then. I would also say that the amount or the frequency of litigation involving the Commission in federal courts is substantially greater today than it was before 1980, simply because there are a lot more industries that are being regulated today. The issues the Commission addresses are changing very rapidly as technology changes. So I don't know if there was a prior practice of commissioners having more influence on litigation or not.
So certainly not within my memory, and both when I was in the Office of General Counsel, it was exceedingly rare for commissioners to ask for or to actually have input into the Commission's litigation strategy. I assume that was just a matter of tradition. Yeah. And certainly now that I'm a commissioner, we've had no input into that as well. And I think in a sense that might be rational, since in the more high-profile cases in which we're divided, typically on the dissenting side, so it would be rather odd for the agency to consult my views about how they should defend the order in court when I'm the one whose dissent hopefully gives a roadmap to the court for overturning the agency's decision. But what I will say is that I do think that, as Harold pointed out, that openness is very important. And in cases where a commissioner would like to know, how is the agency thinking about litigation strategy on a matter where we're all in agreement, that's something that a commissioner should have some insight into. I mean, we are, after all, the ones who are nominated by the President, confirmed by the Senate, in charge of administering the Communications Act. And so it would seem that, having made these decisions, we have a vested interest in making sure those decisions stick, assuming we're the majority.
If I could just add to that, I think that's exactly right. I think the commissioners have a statutory responsibility, in fact, for all the operations of the Commission, including its litigation. You raised an interesting point, though, about majority, and there are precedents for a new chairman coming in and having a different view, because litigation often involves decisions of the Commission years ago. So you can have a situation where a chairman might actually have a different view of a prior majority position. So I'm not sure the majority issue should be binding.
I'm sorry. Go ahead.
I was just going to make a quick point following up on what they've been talking about. I think dissents really matter when you get involved in litigation. Just give 2 quick examples. In the net neutrality appeal, we had only like 10 pages to write our arguments about Section 706. But Commissioner Pai had a 5-page dissent on that issue. And Judge Williams clearly read it and cited it in dissent. So it's very helpful when you're representing a party in litigation to be able to cite to a very persuasive dissent, and the judges really do read them, in my experience. And then the second example is the Prometheus case, where Commissioner Pai's dissent was really a roadmap, I think, to the court's opinion, and actually saved a party from having failed to exhaust an argument. So they do matter, so keep up the great work.
Glad to see somebody out there is reading these things. It just doesn't go out into the ether.
Yeah.
So if you have any questions, for those of you online, again, the address is interactive@wlf.org. I'll open up the floor to those here in person. You'll be handed a microphone, which will just elevate your voice for the benefit of our online viewers. Yes.
In the recent Sixth Circuit case, the Department of Justice refused to jump into the case and defend the FCC's position. I was wondering how often that is, and if that's how often that happens, and how indicative that is of FCC really overreaching in that particular case.
I haven't done a formal survey, but my understanding, and Brett might have a better view, a more informed view, is that it's exceedingly rare. The last one I can think of that springs to memory was in the late 80s and early 90s, when in the Metro Broadcasting versus FCC case, the Solicitor General's office declined to defend the FCC's decision with respect to racial preferences and I think awarding certain contracts, and the agency ultimately lost in the Supreme Court, having to defend its own decision.
But I can't think of another case in which has happened, certainly within the modern era, which is part of the reason why I found it exceedingly notable that in this particular case, given the political salience, I mean, President Obama himself urged the FCC to take this specific action to promote municipal broadband regardless of the legal constraints. And so it was notable that his own Department of Justice said, we've taken a look at the legal foundation, we think it's too shaky, and we're not going to, or we're going to set the FCC loose to defend it on its own.
Yeah, I think it really mattered in that case. My firm represented the petitioner in Tennessee in that case, so full disclosure, but I mean, we used that in the opening page of our reply brief. The Department of Justice can't even defend what the FCC did here. So I think it really did matter. And it puts a cloud over the entire order. If the Department of Justice can't get up in court and isn't willing to defend something, I think that sends a signal to the court and could have had an impact on the result.
Yes.
Hi, Carl Golovin. Commissioner Pai, if you'll please indulge a general question and then a specific follow-up. And if I may refer to my notes, in the event you were initially against an item upon circulation, are you still open to compromise? And may I have a follow-up to that?
Once I cast a vote, if assuming the order hasn't been adopted and released, if there's material new information that's been presented to me or new proposal, then I certainly consider it on the merits.
Thank you. And more specifically, in light of that, does this mean that despite citing special rights to vote against Globalstar in the TLPS proceeding, could similar special rights granted in the same spectrum on a shared basis be a possible compromise in your mind?
Oh, this is a proceeding that's engendered a fair amount of public interest, and I know that Commissioner O'Reilly has been leading the negotiations over how the chairman's proposal could be changed. And I'm not aware of any new proposal that's on the table, but should his or should the chairman's efforts bear fruit, then I'll certainly be willing to take a look at what they present.
Any further questions from our audience here? Online?
So my question is just, given the current political climate and divisiveness in politics and the unlikelihood of a major overhaul of the Communications Act anytime soon, just wondering if any of you could touch on more limited bipartisan initiatives that might be politically feasible in delimiting the Commission's control over the Internet. I know that Mr. Shumate mentioned bringing cases in forums other than the DC Circuit might be a very interesting solution. But one idea I had was just trying to, one problem is that there's a lot of political seesawing between, depending on who's in charge of the commission. And so perhaps, and that's not favorable to either party, perhaps legislating a lower standard of deference than Chevron deference, such as Skidmore deference, particularly in reference to 706, which has been used to in such an expansive manner.
So I'm happy to lead off. I don't have any good insight into legislative solutions, but I think one thing I'll say, I think the Supreme Court needs to weigh in on these important questions. I mean, the D.C. Circuit in particular has been extraordinarily deferential to the Commission, especially with respect to 706 and the interpretation of telecommunications service. I think it's essential for the Supreme Court to have a say in what the law means here and to hopefully put some boundaries around what the Commission can and can't do in this internet space.
I like your focus on the bipartisan nature of it, and I think it's unfortunate that the network neutrality order has taken on very strong partisan overtones on what shouldn't be a partisan issue, and yet it has become one. The network neutrality order was an extraordinary grasp of power by the Commission outside the bounds of Congress and outside of any statute that the President ever signed. So you would think that members of both parties would want to see a more orderly way of creating laws and a more orderly way that potentially could benefit one or the other parties, because they really missed out. They missed out in the sense that the legislative process is very involved, but there are benefits to the legislators in that. The complete circumvention of the legislative process and just creating laws by the Commission, I think it's a great affront to Congress. And I'm shocked that there isn't widespread protests on both sides of the aisle on Capitol Hill.
I would add to Harold's thoughtful remarks that I do think that there is a much more substantial role that Congress could play in overseeing the FCC in a bipartisan way. First and foremost is through the use of the appropriations process. I mean, the power of the purse is constitutionally entrusted to Congress, and I think they should exercise it more often. They have done that recently. For example, with respect to the joint sales agreements that I mentioned earlier, Congress in a bipartisan way overwhelmingly passed a bipartisan budget act in 2015, which prevented the FCC from taking action with respect to certain joint sales agreements. Now, the FCC ultimately ignored that law, but nonetheless, that was an example of Congress speaking with one voice. Similarly, even short of legislation, just holding more regular hearings where they call the commissioners up and ask them about particular questions that are important to them, quite often yields substantial policy results. If a senator or a representative says, I would like your commitment to X, and the commissioners all say yes, then that's something that actually does bind the agency going forward. Additionally, just through sending letters. I mean, one of the most effective constraints on the agency's authority of late with respect to the set-top box proceeding was the overwhelming outpouring of opposition to the chairman's proposal from members of Congress from his own party, from Senate Minority Leader Harry Reid to numerous members of Congress who, at oversight hearings, but also through particular letters, spelled out their concerns with respect to privacy and content protection and the FCC's legal authority to interfere in certain kinds of programming contracts and the like. And that can be very effective, I think, in operating as a check, an informal check, but a check nonetheless, on Commission authority. But moving beyond that to the broader point you raised, which I think Harold is right to applaud, which is on the focus on bipartisanship. When I got into this space in the late 1990s, bipartisanship was the norm, and you could never tell, based on one's political affiliation, how one was going to come down on a particular communications policy issue. And I still remember vividly when attending a hearing of the House Energy and Commerce Committee when it was chaired by Billy Tozan, and he and Congressman Dingell had legislation they were pursuing. And one by one, Republicans and Democrats would go down the line. I remember thinking, I wonder what this congressman or congresswoman is going to say about this particular issue. You couldn't predict as a result. But now, unfortunately, on a lot of the high-profile issues, the political affiliation seems to dictate where you're going to come down, and that's not the way it should be. And so along those lines, I wanted to put my money where my mouth was with respect to supporting bipartisanship. So on September 13th in Cincinnati, I outlined a number of different proposals designed to be apolitical or bipartisan, at least, in nature, that would get us past these divisive debates like net neutrality. How do we promote, within the FCC's authority, a greater ability of the private sector to deploy fiber? How do we ensure that on federal lands, wireless companies can more quickly deploy wireless infrastructure? How can we ensure that entrepreneurship and innovation aren't held back by the application of legacy regulations to new services? Now, some of the proposals which I outlined would require congressional intervention. So, for example, I proposed what I've called gigabit opportunity zones to ensure that ISPs have the maximum incentive to deploy fiber, and startups have the maximum incentive to create jobs in those areas. That's not something I can do or my colleagues can do. We need Congress to step in. But all of which is to say there's a whole bunch of fruits, some of it low-hanging, that I think a bipartisan majority at the Commission and in Congress could achieve, if and only if we're willing to let some of these more tinged debates fade into the background. And I'm hopeful in 2017 and beyond we'll be able to do that, regardless of who controls the executive branch or the FCC or Congress.
Thank you. Any further questions from our audience? I have one last one for Brett. From the perspective of somebody who works with those who petition before the committee and with the commission and write briefs and such, how much does the control of the commission's litigation approach by one commissioner play into the strategic approaches that are taken by companies that decide to challenge FCC decision making?
I don't think it really factors into our decision making when we're trying to advise clients on litigation strategy. Once that order is voted, OGC is bound to defend that order as written by the commission. They can't make policy. So, the lawyers at OGC are very excellent lawyers. They do a great job representing the commission in court honorably and capably, and they're very tough to litigate against. But they are bound to defend that order, and it makes it very challenging.
Well, we're on time. Thank you, gentlemen, for bringing us to the 1 hour limit perfectly, and for joining us today. We appreciate your comments and your thoughts. Thanks to everybody who joined us online as well. For those of you who want to take another crack at watching this or see it in its entirety if you came in late, it'll be available on our website by probably later this afternoon, tomorrow morning at the latest. Thank you again for joining us.